This is Raj versus King County et al. 062-155-157. I'm presuming from the pleadings that this matter can be resolved by oral argument only. Is that correct?
That's correct. For the record, Your Honor, Neil Fox on behalf of Mr. Raj, who is present with the court.
We agree, Your Honor. Saki Amada for King County.
All right. Well, plaintiff was correct in the first place. This was a civil matter, and that's where it belonged. But
I tried to explain that to Judge Lemons.
Yeah. Well, I mean, you're here. You might as well proceed with it. And if there was testimony, I'd probably kick you back there. But for oral argument, I'm not going to make everybody come back. Looks nasty. So,
Sure.
You have 10 minutes.
Thank you. Good afternoon, Your Honor. There's no question that Mr. Raj, who was convicted of a misdemeanor sex offense 4 or 5 years ago, has done everything right. In the last 4 or 5 years, he successfully completed probation. He completed sexual deviancy treatment. He was considered by his treatment provider to be a low risk to reoffend. He has personal stability. He's married. Residential stability. He just purchased a home. He has no substance abuse problems. Proven track record in the community support. I think by any objective criteria, one would have to agree with his treatment provider and the 2 police agencies that dealt with him previously that he should be a level 1, that he presents a low risk to reoffend against the community. But here, after he moves a few blocks, really.
Well, do you have the ability to effectively appeal the substance of the decision of the sheriff in some standard other than arbitrary and capricious?
Yes.
Why?
Why? Because the Supreme Court in Meyer said that the person has a review under 2 different provisions. One is the constitutional writ of review, which is Article 4, Section 6. Basically, 4 and 6.
You say it's de novo?
No, it's not de novo, but if you look at the writ of certiorari statute, RCW 716.120, it sets out the standard of review, and there's actually 5 criteria. One of them is whether there's substantial evidence. Another is, was there competent proof? Whether in making the determination any rule of law affecting the rights of the parties thereto has been violated to the prejudice of the relator.
That would be a legal issue.
Well,
I'm asking the factual. I mean, I realize it's a mixed question, but
so I think it's broader than just arbitrary and capricious. I mean, because I think that the
of course, you want more than less than arbitrary and capricious, obviously. But
right.
All right, so that's 3. Give me 4 and 5.
Well, I'm going backwards actually. So,
all right, I don't care which direction. But
whether the authority conferred upon the body or officer in relation to the subject matter has been pursued in the mode required by law in order to authorize it or to make the determination. That's also key because that goes to procedural due process.
Well, you've always got a due process. I mean, that's another question of law. But,
right, but I think
right.
Just by law, I think that people have the right to have some sort of hearing before their offender level can be raised arbitrarily. I think that the...
So you say it's different than the initial setting.
Right. Well, I actually have 2 arguments.
Well, you may have a client next time who you want to challenge the initial setting. But
today
today you're not there. So.
Well, and we'll deal with that another time.
All right, understood.
I mean, I think the way that the legislature has changed the rules with regards to registration, I think that even an initial determination, a person has some due process rights there. Well, they'll have to decide that now because that's not before you. But I think that the new legislative enactments in the last year, Issaquah's residential restrictions that limit someone's ability to...
The legislature didn't do that, but all right.
Well, a political subdivision of the defendants did that. Issaquah is in privity with King County. I've said it. There's case law to that fact. I mean, they're political subdivision of King County.
Issaquah may doubt that.
Well, they are. They're political subdivision of King County. But apart from that, there's a new requirement that offenders at level 2 and 3 report every 90 days to the sheriff. sheriff's office at the time designated by the sheriff. That's very different than having to fill out 8 items on a form once you move someplace. And I think the Supreme Court in Meyer recognized the statute-specific nature of its holding, because it recognized other cases around the country which have held that where you're making a determination of a level based upon dangerousness or predictions of reoffense, that under those statutory schemes you might have a right to due process, but not under the statute as it existed in Washington in 1999. We're under a different scheme. We have a requirement that Mr. Raj really can't even leave to go traveling for more than 90 days, because he would be in violation if he doesn't physically report to the police station at the time and date once every 90 days that the sheriff tells him. That's a very odious restriction on someone. As I think the Massachusetts Supreme Court recognized, this is a hallmark of totalitarian society, requiring people to report to the police.
Of course, he's in a somewhat different posture. He's a sex offender.
But that was in that context. I mean, and the Hawaii Supreme Court cited to that case.
Hawaii.
Oh, okay.
That was the Hawaii state
Sure.
Constitution. All right.
But then also you have the ability by owners or people.
Although I should point out that Hawaii state constitution happens to be the same as the federal constitution. These issues, but it was the state constitution. All right, go ahead.
You also have the issues of community centers, swimming pools, parks. Under the new statute adopted by the legislature, the directors or the people in control of those bodies can exclude a level 2 or level 3 sex offender from those premises. And so the mere fact that Mr. Raj has been
Well, but
determined,
have they?
they haven't yet, but they
Is that
can.
before me?
I'm sorry?
Well, that's whether or not it creates a liberty.
Right, because what it does is that the driving force behind other restrictions on Mr. Raj's liberty is the decision made by King County. And I think that once you have those changes, then you must have some ability to contest the decision before the decision is made. In this case, we had no ability. We weren't even given a copy of the file until after I filed a writ of certiorari. So we had absolutely no ability.
But you were able,
I could submit.
You did submit information.
Right, but I couldn't submit information geared towards the very factor that they based the change on, because I didn't know what that was until I saw the file, which is the determination that under the form that they're using, Mr. Raj was predatory. Well, actually, he wasn't predatory, not under the definition as contained in the very form that they use. And so then you have the question of, is it arbitrary for an agency or a police law enforcement agency to apply definitions incorrectly? And their determination is that Mr. Raj is predatory because there was grooming. Well, apart from the fact that most sex offenses probably have some grooming going on, unless you have complete stranger attacks, that's not the definition of predatory as listed in their very instrument that they're using in this particular case. The instrument talks about people who prey on who form their acquaintance with someone for the mere purpose of victimizing that person, and that's not what took place in this case. So under their own definition, they didn't follow it. Mr. Raj was not predatory. Then the question is it arbitrary and capricious even under that standard for King County to use a diagnostic tool that's not rationally related to danger if that's what they're trying to determine? As the affidavit from Mr. Comte, which I filed, which I assume the court reviewed, indicates, this tool is designed to evaluate people upon their release from prison. It has no relevance to someone's situation 5 years down the road without looking at their personal circumstances, without looking at their treatment success, without looking at all the accomplishments that they've had in those 5 years. Conversely, to rotely use this, or to use rotely, not to split my affinities, to rotely use this tool would be dangerous, because presumably, if this is the only tool that King County uses to assess someone's dangerousness, you could have someone who's not considered to be dangerous at the outset. It's intrafamilial, they're doing everything right, they're a level 1. The person starts working around daycare centers, they have a substance abuse problem, they have residential instability, and if this is the tool...
I don't know, isn't the tool as much or more than a judge has at sentencing? in taking risks that we take?
Except that what they do is that they're going through it by rote and filling in numbers for factors that have no bearing on a person's personal circumstances 5 years after the fact. The tool is designed for someone's release from custody, and it's irrational to use this tool in this particular case. There's absolutely no basis. It's not a rational exercise of their power because they're using the wrong tools. And we were unable to present that evidence below because we weren't provided with a copy of the tool until after the fact. And that's the problem, is that there's no procedures. The decision administratively is what drives all these other considerations, what other cities within King County are doing about their people, where someone's ability to have to go to the sheriff's office every 1 day. That's all being driven by an administrative decision that there's really no ability to have input into. And I assume that means
Fine.
time is up.
It is.
Thank you.
All right, Fitz?
Your Honor, first of all, the writ of certiorari standard is not applicable here. It's well noted in Washington courts that only quasi-judicial decisions are under this writ. Otherwise, it would be under the constitutional writ, which is the arbitrary and capricious standard. Secondly,
Define quasi-judicial.
well,
I mean, the sheriff isn't the sheriff effectively making a judicial decision?
no, because there is no hearing involved in this. In a quasi-judicial setting, there would be a hearing involved. This is common, such as in land use cases where a person makes a decision over property. I mean, it's clerical. Not to say that this is completely clerical. There is discretion involved here, but it's not quasi-judicial because there isn't a
Well,
hearing.
there was certainly discretion involved when she decided to even consider changing what another police agency had decided.
Correct.
That's a lot of discretion.
Sure. And taking it and to address that issue, Your Honor, the city of Issaquah, the sheriff's staff of the city of Issaquah did make a mistake. They did use the same form, the SOST. They did use the same tool and mark the predatory box. And at the end of the SOST, it does instruct that if you are to mark that box, presumptively the person is a sex offender 2. If you want to move them to a sex offender 1, there needs to be an explanation for that. But City of Issaquah couldn't provide an explanation for why they marked sex offender 1 after marking that notification provision that he is predatory. And that's where that discretion lies, or that discretionary decision lies.
So Issaquah could have changed their mind if he stayed in Issaquah.
They could, and I guess that would be an issue that they would have to take up with the city of Issaquah.
What would be, well, right, I realize that Issaquah would have a different lawyer than you, but would there be a difference between his argument today and that one?
Yeah,
so
they
can change their mind.
If they change their mind, I don't think there would be a difference there either, Your Honor. They would say that there was a mistake in the
So then the
form
sheriff could just say, well, let's make him a 3 next week.
Well, no, because
Why?
Well, the qualifications here under the tool wouldn't make Mr. Raj a level 3.
Assuming Sheriff Rohr did it correctly.
Right.
But if she did it wrong, she could say, oh, I did it wrong, we're going to have to make him a 3. And she could do that.
Assuming
Even
that
though he's done nothing to change, he's done nothing to impact the change, right?
to impact the change of the current decision?
Yeah.
Well, I mean, we would assume that the sheriff's office would get something additional to say that he is a level 3. But at this time,
they had nothing to.
The city of Issaquah?
Yeah,
The
sheriff had nothing new about Mr. Raj that caused them to change his level of reporting.
No, that's correct. But that's why we point out the mistake that the city of Issaquah made in using the tool. They marked a notification provision, and once that notification provision is marked, it's presumptively a level 2 sex offender. Now, the city of Issaquah has made that mistake, and we've noted that mistake and found that mistake. I mean, and we marked this after, of course, doing our own, or the sheriff after doing their own assessment and using the tool for themselves individually, separate from that fact. But after looking at the city of Issaquah's use of the tool, they also marked that
disagree
provision.
with the way it was done. You disagree with Issaquah's decision making.
Well, right, we do in that instance, but that wasn't the basis.
And if he moves to Medina, and this Medina police chief decides, we don't like the way the sheriff did this, he's a 3, that's okay too.
I couldn't speak on behalf of Medina and
No,
why.
of course not, it's a hypothetical, but I
Right,
mean,
but I mean, if they were
the
to see
sheriff
something
can
else
make
that
the
would
decision,
provide,
the police officer, each police officer agency gets to make their own decision of what it should be, depending upon where he lives.
well, the legislature in RCW 4.24 provides that this tool be used, and he
Right.
did allude correctly that usually it's a case of incarceration, DOC would make that determination, but it says in this tool that, and in the statute, that the police agencies make the final determination. Should it be different from the DOC's initial determination, then they would notify DOC as to why they made that change, as will the sheriff's office make notification to Issaquah that we've made him a level 2 because of this mistake. So there is a provision there that allows for that change, but explanation on
But
why.
can't the court consider whether it's arbitrary? Not that Sheriff Rahr herself was arbitrary, but there's an element of arbitrariness and caprice, I might add, but arbitrariness when somebody moves within the state and their level is changed just because they've moved. Not that Sheriff Rahr herself was arbitrary, because she appears to have followed the statute precisely. That's your position also, right?
I'm kind of confused.
She did what she was supposed to do under the statute.
That's correct.
Okay.
But whether it's
All right, he's not
arbitrary,
saying she didn't need it,
I-
but isn't there an element of general arbitrariness that the police get to change the rules just because somebody moves?
No, and it's not based on just because somebody moves. I mean,
Well, it is. If he was still at Issaquah, he's still at 2. I mean, a 1, right?
That's correct. But because he's moved into King County or a city that has an interlocal agreement with King County, the assessment is done by King County for the sake of public safety. I mean,
Well,
to let
Okay, but
and the arbitrary standard. I mean, it would have to be willful and unreasoning action. That was not done in this case.
right, not by Sheriff Rahr,
Right.
but isn't it willful and unreasoning to have to do it each time somebody moves? If you're going to increase it anyway.
Well, I think that would be something to address with the legislature. They have given the authority to the police agencies, the local police agencies, to make that determination once the offender has moved into their jurisdiction.
Yeah, but
I mean, the transfer of
we only
what
have
you
one sovereign here, and that's the state.
right, but the legislature has given the power to the local police agencies to make that assessment once the person moves into the jurisdiction.
Well, that's right. I mean, there's no question about that. But that doesn't resolve the due process question.
Well, due process here, in Meyer, it's clearly stated that these sexual offenders do not get the liberty interests attached to them.
Well, there's no question they're entitled to some process, right?
Well, only if you're referring to...
The question is how much process is due.
Right, and I think Meyer addressed that in their very last paragraph of the case. Where it does state that it would be wise for the agency to provide some access and notification and for these people to be heard. And that was provided in this instance in the form of letters, correspondence with his attorney. Notification was given by Detective Billingsley that he was to move to a level 2, and upon their request, he investigated further the City of Issaquah's decision, and also allowed him to send in correspondence and letters regarding all of that.
But wasn't allowed to see the file. And nothing.
Well, and statutorily, it's not required. If he was to make a public disclosure request or something along those lines,
he made a feeble attempt at the last minute, but there was no chance that was going to be. Right. I mean.
Although we have, concerning that interrogatory, we have provided.
Well, that's right, but it's kind of late. I mean,
well, sure.
Sheriff Rohr doesn't help him in terms of addressing Sheriff Rohr.
Right. And as far as his the predatory, I mean, by statute, predatory has been defined, and he's saying that Michael Conti, his therapist, is suggesting that he should take into consideration the dangerousness of this person, and statutorily that wouldn't be required.
Well, isn't that what we're doing here? Isn't that really what we care about?
The dangerousness.
Yeah, that's all we care about.
Sure. But the sentencing guidelines even say, these people are to register for a certain amount of time for the felony that they have been convicted for. He's pled to a Class C felony, so statutorily.
Only misdemeanor. It was communicating, is that right? Yeah. Misdemeanor.
Oh, okay, so misdemeanor. So even under that statute, I mean, it's
right.
In the sentencing provision, it's 10 years. So the state has developed that. So for 10 years.
All right, but they're not disputing that they're under the jurisdiction of the state for 10 years.
Well, he is disputing that we're not taking into consideration the dangerousness here, but statutorily, we're not required to do that. Statutorily, we're required to assess based on this tool. And based on this tool, we've decided that he has been predatory, and because of that reason, he's to be labeled a level 2 sex offender. I mean, it says here also in the actual tool here that the Board of Sentence Review Committee, and I'm sorry, it's on CERT 278, decided to base the risk level classification screening tool for several reasons. Scientific literature on prediction of future dangerousness holds the mental health professionals' clinical predictions are generally no better than chance. So they have addressed that particular issue.
All right, that's your time. Thank you. Let me hear a brief rebuttal.
Very briefly, the legislature never told the county to use this tool for reclassification. There's nothing in the statute that requires them to use this particular tool by
for reclassification.
Or actually for any classification. I mean, they don't have to use this tool. They can use the tool. Okay? But to use this tool,
so it's like a double jeopardy thing as far as you're concerned.
Well, no.
Semi-double jeopardy.
No.
Surely you'd agree they could increase his level if they had evidence that he did something.
Sure. But
whatever, hanging out at swimming pools or something.
But if they're, and I guess this goes to my interrogatories, which I don't think are too late, because I don't believe that the county has any rules at all for reclassification. And I'm curious to know whether they have reclassified people up or down.
You mean within the county? Within
the county. Does the King County Sheriff's Office have any rules at all for any separate procedure for reclassification? And again, the legislature hasn't required them to use this tool in this particular instance. With regards to Issaquah, Detective Billingsley states in her declaration that she never contacted the city of Issaquah. All she did was look at the documents that she got from the city of Lake Forest Park, which adopted Issaquah.
What Issaquah?
So we don't know that Issaquah got it wrong. They may have not filled out the form properly, but their decision may well have been right. We can't just say, well, they got it wrong and King County is correcting that. We don't know because the county never contacted Issaquah. And then finally, with regards to quasi-judicial and the writ of certiorari standard, we're here under the writ of certiorari because the Supreme Court explicitly held that someone like Mr. Raj has a right of review under that statute. So that question has been answered. They cite to the writ of certiorari statute. They don't just cite to Article 4, Section 6. So we're here under both writs of review. So for all those reasons, I would ask that this court either order King County to keep Mr. Raj at a level 1 or to send it back and let the county give us a hearing where we can bring in Mr. by the way, was not the treatment provider but a separate expert. The treatment provider was Mr. Hirsch, who made an opinion that Mr. Raj was a low risk to reoffend based upon treatment, but Mr. Comte was the one that talked about the tool. And I'd like to present that information at a hearing.
All right. I think that it's not a clear call whether or not there's a liberty interest involved. Even Hawaii said the registration requirement doesn't implicate a liberty interest. And then took it a step further and said in Guidry that the requirement of lifetime registration does, under the state constitution, create a liberty interest. So there's some, and whether or not there's a liberty interest in 10 years versus life in Hawaii remains unclear to me. And also we look at whether registration has recognizing that this really is the ex post facto argument and not the due process argument, but whether it has some whether there's a punitive effect of registration. Certainly registration does have some punitive components, but I agree that with most courts that it's basically a regulatory thesis. Of course, we don't doubt that the petitioners are entitled to some procedural due process. And the question again is how much process is due and whether that process was met here. Adams, In re Adams, concludes that minimal due process requires written notice of the reasons, in that case the Department of Corrections is seeking to change its classification and an opportunity to challenge the facts. Now, of course, Adams dealt with more of a liberty interest because there we're dealing with early release, and there are some distinctions. I think here the amount of process is close but wasn't met by the sheriff, and I'm talking about constitutional process. I think the petitioner is entitled to the opportunity, not necessarily, and if the sheriff chooses to do this, that's her choice, but not constitutionally entitled to a fact-finding hearing with witnesses and oral argument before the sheriff. But I think that they have to be entitled to the opportunity to present evidence, and in order for that opportunity to be meaningful, they have to know what the sheriff is taking into consideration in making her decision. So at least to the extent that where a police agency is seeking to change the level, I think the appropriate remedy here is to remand for a fact-finding hearing before the sheriff or her designee, with leave to the petitioner to submit materials and evidence in response to which the petitioner is now able to do because the petitioner has that information. The sheriff's going to be in a better posture than the court is to simply rule on this, make this decision. And I think it's up to the sheriff, not the court at this point, to decide how much process beyond simply submitting written materials is due. I mean, she can decide to hold a hearing if she wants. I'm not finding she's obliged to. When I say a hearing, I mean a hearing with witnesses face-to-face with oral arguments. Of course, there's a hearing in effect. It's like the non-dispositive motions that the courts decide. I mean, we call those hearings, but we don't hear anything oral, AU oral. So that's my decision.
Since that doesn't conform with either of the proposed orders, should we just write?
You should be able to work out an order. If you can't, you're going to have to note it up in the presentation. And you might be able to work on it now.
Sure.
20 minutes, I don't know.
Okay.
Save you a trip.
All right. Thank you.
Thank you.
Thank you.